I went into federal court yesterday to file my claim. And by the way, I got it filed. And the woman who's the senior, she's not the head clerk, but she's a senior clerk, and she's actually the clerk for the judge on my case. So they called her over, and when she came over, everybody else came over. They want to hear what she had to say. So she's coming over to me, and I'll keep this short because it was actually about a 40-minute go-around. But it was interesting. She came over to me and she said, Mr. Fall, you're just going to get your claim rejected again. And I said, well, first off, I'd appreciate it if you didn't call me Mr. Fall because that's not my name. And secondly, I'm fine with them rejecting it because I have a remedy for that. What you did to me before was you mailed it back to me without giving me my file number. That's wrong. You don't have a right to do that. And she said, well, we only accept complaints. And I said, that's fine. I don't have a problem with you accepting complaints. I'm not giving it to you. I'm giving it to the public courthouse. And I'm expecting you as my public servant to record it in the proper section of my public courthouse. I'm not giving you a complaint. And she said,
that case number is nothing but an identification tab that gets put on your case with your claim so that they can locate it when the jury is seated. That's the only purpose of that case number.
Right. Exactly. And we ended up getting there. But it was interesting. It was like, these people are so programmed. It's unbelievable. By the way, they seem like pretty nice people. And she said to me, well, this is a complaint. And I said, no, it's not. Do you know what complaint means? And she was stunned. Nobody had ever asked her that. It was obvious. So I said, it means to whine. Do I look like I'm whining right now? I'm not whining. I'm happy. I'm talking with some nice people. We're having a nice conversation on a nice sunny day. I'm not whining. So this isn't a complaint. And then she got clever with me, and she said, well, it's a pleading. And I said, no, it's not a pleading. Do you know what pleading means? And she was stunned again. She was looking around like for someone to help her. So I told her what pleading meant. And I said, now let me ask you a question. Do you know what claim means? And she said, no, I don't. And I said, well, let me tell you what it means. So I told her what claim means. So it really does help for you to know what your words mean when you go in there, because that process is what led her to give me my file number. She realized that she wasn't going to just walk all over me and create a presumption that I didn't have a right to file my trespass in there. And she said, well, she kept saying it over and over. I feel real bad because he's just going to reject it, and your $400 is not refundable. And I said, well, as you know, nobody has my permission to trespass on my case, and I'll seek a remedy for that. She said, what do you mean? I said, well, it's not necessary to get into that right now. There's been no harm done. We'll talk about that after the harm is done.
Now, as far as the $400 is not being, that's nothing but a court rule. That $400 is you're paying a rental fee on the use of a public courthouse room. So that's a fee to use the room. That's not an application fee for a complaint. It might be in the case of a person filing a complaint, but when a man's filing a claim, if you're willing to pay that fee, even though the courts are really supposed to be a benefit for man, it's supposed to be available. If you go ahead and just pay the same fee everybody else does, you're paying for the use of that room for the duration of that case.
Well, let me comment on that, and this is purely speculation on my part, but I feel pretty confident that what I'm about to say is accurate. I believe the king doesn't pay to use his court. So when you pay, you're asking for a license. In other words, you're asking for a privilege because you shouldn't be paying. So to cover myself, I put on the check donation, no license formed. And I feel pretty confident that that's how they look at it. When you pay for any of these things, they're looking at it like you're purchasing or renting a license for a privilege. Because the king doesn't pay. And there's some pretty good arguments out there that I've read over the years for that principle. But anyway, even if I'm wrong, I play it safe, and I just write on there, No license requested. And this is a donation.
In New Hampshire, the Bill of Rights for New Hampshire specifically says that that we have the right to obtain right and justice freely without being obliged to purchase it, completely and without any denial, promptly and without delay, conformably to the laws.
There you go.
So, yeah, it's extremely well expressed in the New Hampshire and Massachusetts constitutions. And I'm sure it is in many of the other original constitutions.
These guys have injustice down to a science. And that's what when I hear some of these people calling in, I sit here and I feel bad because I think they really just don't have any idea what they're walking into.
No, they don't. They don't.
Yeah.
And, you know, that case I'm working on in Vermont, you know, we got a case number over a month ago, and we've been putting paperwork into the case, getting notices written up, and just we've been taking it slow and just taking our time, making sure that the case is complete and ready to go. The suit is complete, and we put in we wrote a letter to the clerk 2 weeks ago, letting the clerk know that the suit was ready and it was complete and ready to serve on the other party. And first there was a big question about the summons that I had written, that you know, they couldn't use this summons because it wasn't their summons. I mean, there's not one single piece of paper in that court case that did not originate with me. I didn't use any of their stuff. So the summons is no different. And so they had a hard time with that. And then finally, they got to the point where, okay, the summons covers the necessary points of law, whatever it is that they think needs to be on there, is on there. And actually, I think I worked on that with you. And then the only thing that's left is the chief judge does not want the Smith court to go into his courthouse. That's the only thing we've got left. And we're trying to, you know, overcome that now. And, you know, I wrote a pretty serious letter to the clerk last week, and, you know, he's just waiting to hear back, you know, waiting to find out what to do with it. Now, one of the options, of course, which we were going to do on Wednesday this past week, is go to the courthouse and get 3 certified complete copies of the case file so that we could go to the sheriff's department after we go see a notary. We could issue the warrant ourselves, not the warrant, the summons ourselves, and get 3 copies, get them all notarized, and give 2 to the sheriff for process service, take the other one and scan it for data witness and have it served electronically. So, you know, that's what I was going to do. I ran out of time this week, but it's very likely that that's what we're going to end up doing if the clerk does not sign the summons. However, I would prefer to battle it out with the court and get them in as much of a submissive position to the Smith court as possible before the other side shows up. Why have these kinds of arguments when the other party is there trying to get their way the way they usually get their way, with the statutes and the codes and the proceedings and the rules? And, you know, if we can get the court completely converted to a common law court with common law rules before the other side even shows up, it'll make the rest of the case that much easier.
Yeah, that's a great strategy.
So that, you know, the lady I'm helping out is kind of stressed over how long it's taking, but, you know, she agrees. It's a lot easier to get this dealt with before the other side shows up. So that's, you know, the other case that's similar to that is the one that I'm dealing with in New Hampshire, where we're converting a statutory case over to common law rather than filing our own claim. And that's been a pretty interesting learning experience. And I had done it, and then Karl asked me about it. And, you know, the number one thing he was looking for is, did they object when you converted the case? And I said, no, they never objected to anything. And and you could tell by his tone of voice that success was on the horizon.
Oh, that's good.
He says, "Wow, they didn't object." I said, "No." He says, "Wow, that's really good."
That's good.
Yeah, so it's just a matter of time, But of course, if that doesn't pan out, or if I get too frustrated with it, we'll just go ahead and start a new case, get a claim number, and just start fresh rather than try to convert a 7-year-old case.